March 12th, 2014. First matter is the adoption of last meeting's minutes. Does anyone have any additions or deletions from those minutes? Motion to approve the minutes from the last meeting.
I'll move we adopt
Second.
the minutes.
Seconded. Thank you. Motion carries. Staff, any additions or deletions on the schedule on the agenda for today?
Under request for board order, case B 13 CE 4187 outlier investments is being moved from request for board order to a notice of assessment appeal.
Thank you.
I didn't hear it. Could you repeat that, please?
13 CE 4187 item B under request for board order outlier investments is being moved to a notice of assessment appeal.
Thank you.
That'll be heard as item 3A2.
Any other changes?
Were you going to pull a case?
No.
All set then?
Which one?
Just a minute. 3C 2A, Jack McInerney.
3C.
Sorry, I don't have it on my new agenda, so I didn't.
3C.
You're pulling that, correct?
Correct.
Which one is it?
Case 13 CE-4604, Jack McInerney. It's 2A.
Ah.
He's complied and paid his citation.
Thank you, sir. So I move we accept the agenda as modified.
I'll second.
So moved.
Sorry?
So moved.
Thank
Did
you.
vote on it?
Motion carries. Okay, Sherry, would you get everybody sworn in, please?
If everybody that's going to testify would stand, please, and raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Great. Okay. Sherry, I'd like to see the folks that are here first, if we can manage to make that happen.
I think that's all it is.
You're absolutely right. Oh, quick question to Officer Sanderson, just so I understand a little bit better. We had Mr. Nyquist last meeting. Looks like he had entered into a compliance agreement.
He had
And-
spoken with Tim prior to the hearing and was to enter a code compliance agreement. That agreement was never completed, so he is back today as his original request to appeal the citation.
I see. Okay. Well, thank you then. So we'll have his case first, then case number 13-CE-4467, Anders Nyquist.
Hello, everyone.
Hello.
If
Does
You were
staff
sworn in?
speak first, or how do
Staff will speak first.
Okay.
This request for notice of assessment for case 13 CE 4467. The violator B. Anders Nyquist Jr., Nyquist Trust Number 2, was cited for a violation of a stagnant swimming pool at 1177 25th Street based on a complaint by the Vero Beach Police Department. Service of the citation was provided by certified return receipt to the owner and is on file with the city clerk. A request for the hearing on the citation was received January 30th, 2014, and was scheduled to be heard by the Code Enforcement Board February 12th. Mr. Nyquist met with the planning director on the morning of February 12th and agreed to enter a code compliance agreement with the city to resolve the code violation. The code compliance agreement was emailed that afternoon to Mr. Nyquist and has never been signed and returned to the planning office. On February 19th, I sent Mr. Nyquist an email requesting he complete and return the code compliance agreement and received an email response on February 21st from B. Anders Nyquist III that his father was on an international cruise and would return on February 28th. As of today, the planning department has not got a signed code compliance. The violation has not been corrected as of March 12th. The civil penalty on the citation has not been paid. Enforcement costs of $329.83 are requested by the city.
Now, you had stated this was If I may, Mr. Chairman, a request for notice of assessment, this is an appeal of the citation, so you need to put on your case as far as the violation, show the violation. My understanding is there was not a waiver of the hearing. In fact, there was a request for a hearing.
Does that mean we're falling under assessment appeal?
I'm sorry?
Is he falling under assessment appeal at this time?
No,
Is that what you're saying?
no, this has never been acted on by the board.
Appealing the citation.
Yeah.
That's how
Yeah,
we have it done.
yeah, it's an appeal, so she has to put on her whole case, her full case.
Melody, we could put that
Thank
up on
you.
the doc cam if you give me a minute.
On the screen right now is the complaint through the police department of the property.
That's how new I am.
That's the pictures of the stagnant swimming pool.
These are, let's say, March 11th. That was yesterday's picture?
Correct.
Okay. Can we invite Mr. Nyquist up to speak now?
And Mr. Nyquist, if you have any questions of the officer, you can certainly ask questions of the
Were
officer.
those pictures taken yesterday?
Yes, sir.
So the doors were open like that?
The doors have been open like
Because we've
that.
secured those doors, we posted no trespassing signs, we put blocks in front of the doors. There's a 7-foot wall surrounding that pool. So I guess that's the second time that you've been out there when the doors have been open?
Correct.
Well, it's a problem that we have there. This is a property I've owned for 30 years. I own probably about 75 properties within the city limits of Vero Beach. I've been in business in this town since 1977. It's my first time I ever appeared before the Code Enforcement Board. You may not know me by name, but in the late 90s, I did a lot of historic renovation downtown. I did the Regent Court, which got listed on the National Registry of Historic Places. I did Brazilian Court, which we won the Mayor's Award from the city for the best restoration in the city that year, along with some other properties. So this is the first time I've ever been before the board. But with this particular property, the first notification I got from the city that there was a problem here was by certified mail, and the officer stated the date. And in the certified letter, there was a fine being assessed. There was no notification prior that there was a problem, giving me a period to fix the alleged violation. When I received that certified letter, I came in and met with, I was going to meet with Ms. Sanderson, but she wasn't in, and Mr. McGarry was. So I met with Mr. McGarry, and we discussed the situation. I explained to him, I said, I've received no notice from the city with, telling me there's a problem and giving us a chance to rectify and abate the alleged violation. He said, well, let me look into our files, and if that's the case, then we're not going to push for a fine because there has to be some type of due process. and then we agreed that, this is basically the ordinance calls for the water not to be stagnant. That's the problem. So it wasn't a health safety issue because there was a 7-foot wall, and these doors, they were, I don't know who's done it now, again, but we've been having problems with either kids or vagrants, looks like someone even knocked down one of the doors now. But I met with Mr. McGarry, and he said, well, we need to get the water circulating so it's not a mosquito issue. I said, that's fine. What I'll do right away is I'll get some mosquito larvae prohibitive it's powder form. You put it into the pool, and I did that, and I did receive the stipulation that he sent me, but the stipulation that he sent me was a lot more than a stipulation. One, it's admission of violation, waiver to right of hearing, and further, it's erroneous to the extent that the address to the property is a different address than what this property is. So certainly I couldn't have signed this, and you're welcome to look at this if you like, but I highlighted, he's actually got my office address here. So, I couldn't enter into a stipulation that's erroneous, and that's why I didn't sign it. Then also I had a family cruise, so we were out of the country for 10 days as well. But another one of the things that Mr. McGarry and I spoke about was to get, the power's been off on this property. I use it, it's a 6-bedroom house, and I use it mostly just for personal storage. But one of the things, in an effort to get the water circulating again, was to go to the building department, get an electrical inspection permit so we can get the power turned back on and get the pump running. So as an effort of good faith, I did go to the building department, get the permit for the electrical inspection so we can get the power back on and get the water circulating and abate the violation. But it's not a big deal to fix. I just need some more time to do it. And I don't think there should be any fines because I've never really had a chance to fix things before the city wanted to assess fines right away.
Okay. I have a question for you, Officer Sanderson. Would he be expected to have a notice of violation before a fine? By he, I mean Mr. Nyquist.
Once the complaint was originated, a courtesy letter was sent December 6th regarding the pool to the office address. A warning citation with no fine was sent on December 23rd, and then it goes to a citation with a penalty.
Mr. Nyquist, you
Yeah,
did not receive?
I spoke with Mr. McGarry about that, and we didn't receive any previous mail other than the certified mail. Now, we have 2 trusts that I administer. One of the trusts, we have a forward on the mail to go up to our northern address in Wisconsin. And it's a possibility that mail might have gotten forwarded, but I didn't get it, and I'm assuming it was sent regular mail and not certified. Is that correct?
Correct.
I never got it. It might have been some of the stuff that got forwarded up north. And the first notification that I received was when the mail carrier caught me and said, you have a certified letter. And the very first certified letter that I signed for called for a fine immediately. It says right in the body of the agreement there's a $50 fine or something like that. Mm-hmm. Well, I don't know. There's got to be some operating procedure with notification with people that are expected to pay fines other than just levy fines without any previous notice.
Mr. Chairman, if you like, I can clarify. The code does not require any kind of warning in advance of issuing a citation with an assessment of a penalty. However, I think policy, Mr. McGarry is here now, he can talk to what their policy is. I think they do try to work with people ahead of time. As the officer testified, they had sent some things. obviously, if someone doesn't get it, it's not necessarily the city's fault.
Sure.
And it's not a requirement to
I
send
have a question or
warning.
two. When did you become aware of the situation, and when did you do something about it?
I became aware of the situation when I received the certified letter. I believe Officer Sanderson stated that date was, if you can help me,
You signed for the letter on 1/27/14.
1/27/14.
And what have you done since then?
I met with Mr. McGarry on the stipulation to proceed. I told him that I needed some time in which to get the electrical permit so we could go in and get the power back on and get the pump working again. I told him that I would put the mosquito larvae impellant in the pool.
Did you?
Which I did, yes.
When?
I did that the day after we met.
What day did you meet?
We met on was it the 12th? Ma'am,
February 12th.
February 12th, so it would have been 13th.
If I might just make a little
Sure.
point of clarification. Also, on the compliance agreement drafted by Mr. McGarry, it was realized that same day that it was sent out that the address reflected the office address and not the violation. Mr. McGarry corrected it and emailed it the same
At that
day.
meeting?
That day.
That day.
But that wasn't a mistake on the actual citation. That was a
No,
mistake.
that was on the compliance agreement.
Okay. And
And just another clarification, I don't know, when did you file for the building permit to turn the power back on?
Today.
Today, okay, because, good. As of this morning, I didn't reflect that, so
Would
good.
you like to see this?
Nope, that's good.
I have another question.
Yes, sir.
How long have you been back from your cruise?
We got back on the 28th of February.
Thank you.
okay.
And if I can just add also, one of the items that officers, is it Sanderson? Sanderson had in her document was that we needed to empty, and the language that she uses is the pool needs to be emptied. Now, I spoke with a pool contractor, and this is an old home, probably built in the late 40s, and the pool is 10 feet deep. And the pool contractor said, if you do what the city's telling you to do by emptying the pool, the groundwater is going to push that shell up out of the water and crack it and ruin it. So he said it cannot be emptied, but the language in her in her letter to me says that the pool must be emptied.
Did you ask anyone at the city if it needed to be emptied or just cleaned?
I
or-
spoke with Mr. McGarry about that same issue when I met
Okay.
with him. And,
Well,
and
that's kind of typical, I think. If there's no electricity, there's no way to circulate the water, so the only way to get rid of the water is to get rid of the water.
but I mean, I got the electrical permit today. We can get the power on, get the water circulating, then we're not in violation. You know, I just need a little bit more time to
Like,
do it.
what kind of time are you talking about?
How often does the board meet? Every month? Before next board meeting?
Mr. McGarry, anything you wanted to say with regard to this case?
Yep.
Yes.
Oh, that's right. Thanks.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank
I mean,
you.
the basic facts are, as Mr. Nyquist said, but I think you have to understand, when he came into my office, I believe it was on February 12th, he explained that, and I said, look, we're not here to punish you. We want you in compliance, and you need to work with us. So I said, we'd be willing to ask for a continuance of the hearing if you'd come into a compliance agreement, meaning you wouldn't have to pay a fine. You find you in compliance. We talked about the pool situation and what was stated for him to come into compliance. I said, no, there are other ways you can do it, and we did agree that he could have, if he recirculated the pool, we wouldn't have a continuing problem with the mosquitoes. He needed a permit. I was going to give him a month for that. It's all in the compliance agreement, and under good faith, we thought we had a commitment there, and clearly we didn't have there was not the same feeling about that, but I did follow up. It was the day after on the follow-up on the the compliance agreement, I realized I had the wrong address on there. We did follow up the following day on that. So I just want you to be aware of the facts, and that was the staff's on this. We like to come into compliance agreements so they don't have to come before you. We're not here to punish people. But I also feel that when I have an agreement with somebody, I believe that they're going to come through with it. If he had a problem with my compliance agreement and I had worked it out with him, then he surely could have contacted me. We're very amenable to making changes. We don't want to waste time before you all on on dealing with this thing. We just want this thing to take care of this nuisance in the neighborhood. So, unless you have some questions to me, I just
Am I
wanted to.
allowed to make a statement, sir?
Absolutely.
Well, I, for one, would have a problem waiting another month for compliance on this. That's green. I don't know what's in it, and it could be a health hazard. So 1 month is not acceptable to me.
Okay.
Does anyone have any questions for?
If I may just address what Mr. McGarry said. I went back and searched my email today. This is the only compliance agreement that I received. But when we spoke of a stipulation. And I mean, I deal with stipulations in the court. But this is so much more than a stipulation. One, it's an admission of violation, and it's a waiver of right to a hearing. We never spoke of that when I was in his office with him. Basically, we just agreed that I was going to bring the property out of violation, not to waive any right of hearing. And I mean, this is so much more than the language in this is so much more than what it is. I mean, this could make me a repeat violator and have to waiver of hearings and admission of violation. So, I mean, the language in the agreement itself, and then, like I said, the agreement that I have, the only agreement I received is erroneous as to the language or the address. He says he mailed something else. I searched my email today before I came to the hearing here. I couldn't find anything else. I just had these two items. But if 30 days is too long, can we go half? I mean, just give me a little. I don't want to, I'm just trying to think in case there's a problem when the electrical inspector comes and we have to do something to fix it, and things take time. So, I mean, if maybe 2 weeks would be acceptable.
Mr. Chairman, in this type of contested case where you've had the evidence presented to you, what the board needs to determine is if there was a violation, of course, and then the code does require you to allow a reasonable amount of time to make the correction. Mm-hmm. And you can impose a civil penalty. You can withhold the civil penalty. If costs have been requested by the enforcement officer, then the city is entitled to those enforcement costs.
Okay, and for the record, can we impose a civil penalty and extend, or is that it? Once you've imposed a penalty?
Typically what you would do is, because you're required to give some reasonable amount of time to make the correction, mm-hmm. Typically what you would do is let the time run for the correction, and then when it comes back before you, either with a report of correction or that it hasn't been corrected, depending on what that report is, you would enter a final order at that time, and at that time you could still impose a civil penalty if you had found there was a violation, and still impose the costs at that time. But typically what you would do at this point is allow a certain amount of time for the correction mm-hmm. of the violation.
Mm-hmm. Okay.
No, I have another question.
Yes,
this is a picture taken today?
Yesterday.
Yesterday. Thank you.
I mean, I agree that we're not here to punish people. And I agree that, you've done some things to come into code compliance with this pool. Definitely don't want to see it go for another month. Kind of feel like you've done the minimum amount to get it where it is now. But you've done something and you're here today, which I like to see. I mean, if you have a problem and you show up, then that says, you don't believe you're guilty, and I'm not here to say if you are or not. I would like to make a motion that we give him an extension to correct the violation, and I'd like
you need to make a finding of whether there was a violation or not.
Okay.
What does that take, a motion? Does that take?
Does it?
Oh, yeah.
I make a motion to find a violation of guilty in this matter.
And the amount of time to correct the violation is what else we would need in there.
Yes, and
I would give him no more than a week.
Okay, second.
I think a week isn't long enough for what he has in mind, but
I'll amend it to 2 weeks.
Do I have a second on the 2 weeks?
14 days to be exact from today.
I'll second.
All in favor?
aye.
All opposed? Motion carries. Thank you, Mr. Nyquist.
2 weeks.
You have 2 weeks.
And then just contact staff.
Sherry?
Yeah, it's real important to get back in touch with,
With-
the officer
with the
once
code
it's
officer.
it's straightened out, and then she can re-inspect it.
Okay, all right.
And
Thank
if you come into compliance to the 2 weeks and you let me know, we can stop any
Okay.
action.
All right, great, thank you.
Thank you. Okay, we don't have any notice of assessment appeals.
You
You have
have
that case-
outlier investments, which
Oh.
is a notice of assessment appeal, actually.
Okay, is Matt Martise here today? Sorry, Officer Ramsey, you said what?
We have another request as well. Another party is here.
Which is that?
Well,
It's case number, notice for assessment 1C.
Let's see. Thank you.
Well, what case are we hearing?
Right now, we're going to hear Matt Martise Outlier Investments, and
Okay.
that is 13 CE 4187. We'll see 13 CE 4513 after that.
And Mr. Chairman, just
Yes, sir.
so the board knows, this is where a notice of assessment has been issued. So the issues are, how long has the violation been in existence to determine the amount of fees and costs that are to be assessed.
Okay.
In other words, the evidentiary hearing was apparently waived by no request for a hearing.
Mr. Martise requested through our office to appeal prior to us going to hearing with the notice of assessment. It came through our office rather than through city clerk, so
well,
But-
there was a notice of assessment issued. They requested an appeal to the notice of assessment. It was on for today for a final order.
correct. So Mr. Martise is here today. He was originally cited with failure to mitigate trees that were removed without a permit, and he is here today to explain what he has done and ask for the board's consideration.
Okay. Mr. Martise, you were sworn in?
Yes,
Okay.
it was. I just wanted to, it has to do with the timeline, and once you see the pictures, I've gone actually above and beyond what the permit required, but for this particular house, it was a renovation. Many permits were pulled, I mean, even including the right-of-way for the pavers, so I thought I had everything in order. The tree permit got past me. I didn't pull it, I didn't know, contractor didn't tell me, the tree service didn't tell me. So when I originally got the code enforcement thing, as you can see there, that was in the middle of guys cutting down a couple of palm trees. And that was the extent of what was cut down. So I applied for the permit. The permit was issued several weeks later, and then when the permit was issued, it only gave me 30 days. At that point, we were having like a hurricane every other day, it seemed. The weather was crazy. And for the extent of what I wanted to do back there was no way I could get it done, with where things were in renovations. So since then, and my other problem is in the mitigation, they called for 15 inches of palm caliper, at least 10 feet high. Well, that's a little tough to do. It's not something that I had in mind, and I didn't know that I didn't know that things were going to be that specific when I got the permit back. I thought it was just like total caliper that you had to make up for. So since then, she has other pictures, and I actually saw Ms. Sanderson there this morning.
Here's the after-the-fact tree removal permit, advising the trees that were removed and the conditions of the permit to mitigate.
Now, the trees were removed because they were right next to a pool, and they were pretty much breaking the concrete in the pool.
Okay. That
So
doesn't
it was a matter of, it had to be addressed. I thought it was on the site plan. I thought by being on the site plan, the absence of being on the site plan, maybe it was approved. I didn't know that I had to go through a permit process for it, and no one told me.
Yeah, the fact that it was cracking the pool deck has nothing to do with it needing a permit pulled or not.
You're absolutely right, but I'm just saying it was an issue that it's not like it was trying to be hidden. Had I known, I would have filed for that permit as well, just like every other one.
I have a question. How long have you been in business?
Not even 2 years.
Thank you.
It's just a couple of houses that I purchased, renovating.
Officer Sanderson, is there anything you'd like to say with regard to what you...
And since then, I'm sorry, I'd like to just point out one more thing.
Yes, sir.
On the property now, there's 20 palms that I've replaced and 45 Simpson stoppers, which are the hedges that are about 3 to 5 feet high. So I've replaced, to date, 45 plants that are between 3 and 8 feet high, plus several dozen small.
You've replaced these plants, or you've added to the plants that were already on the property?
Well, there was really nothing else on the property, so replaced, added. There was just a bunch of oak trees and those palms before. So pretty much, everything else on the property was a foreclosure. So everything got graded, it was leveled. It was kind of a complete renovation.
I want to let Officer Sanderson speak if she has something to say with regard to when you pulled up to the property. I remember we had a short conversation about this in the last meeting, and there were, was it 3 trees that were?
Yeah, there was 3 palm trees that were
Three palm
removed.
trees that
3
were-
20-foot palm trees.
Okay.
When it comes to mitigation, it's a calculation done through the planners, through the planning department, so I don't know.
Right, you
what is
don't have
required.
anything to do with how tall the tree needs to be or the diameter or anything like that?
Correct.
Okay.
But I have seen the property, and he has a tremendous job of improving the property. He hasn't satisfied the requirements of his tree permit, but he has done good work.
Do you have something to say, Mr. Noonan? Go ahead.
The mitigation requirements, all that landscape stuff is in the city code, which is online, that everybody can look at it. You can see exactly what it is you need to do prior to chopping down any trees. Permit requirements are also there. I think
That's right.
I'm a pretty big proponent of ignorance is no excuse, but if Officer Sanderson is of the opinion you've done an adequate job mitigating.
I didn't say that.
Oh,
No,
okay.
nope.
I'll weigh in on mitigation. The mitigation is through the code. I'm just saying I have seen the property.
And I'd like to say that I've done everything, including the right-of-way, which I know a lot of people don't even do with their pavers. I've done a lot of due diligence, and if it's because I haven't found a certain website, trust me, I've looked. But there's not a whole lot of places out there where you can go. A guy like me that's not really, I'm not a contractor. I have to hire all my contractors out. So there's not really a place for me to go that someone can just answer my questions that
Yes, there
has
is.
knowledge like that.
The city planning department, they're very helpful.
Well, you say that, but I've been there many times.
I've dealt with them a lot.
Well, I'm sorry. Now you're telling me that I haven't done my due diligence, but in fact I have. I take this very seriously. I've put a lot of work into this house, and I'm not going to. There's no way I would sacrifice this and run into this for a $50 permit fee that I could have filed. There's no way. It's not something I'm trying to hide.
Does anyone have any questions? Anyone? Any questions?
The only question I would throw back out there, did you testify that the mitigation required has not been completed as far as the trees?
In other words, you're asking if the trees that were requested to be replaced have
Right.
been-
In other words, with the permit came the mitigation requirement, and doesn't that typically get inspected by the planning department once the mitigation is done
Correct.
to make sure that they've met the requirement? It's not something you do, it's the planning department does that.
Or they ask us to shoot a picture and
I
bring it
got
back for them for verification.
Sir, would you agree with me that you made a mistake?
Absolutely. But it's not a mistake that, for a permit fee, it's not like I don't have the permit for the house or any other permit. I pay all my permit fees. I try to do all my due diligence. you know? The palm trees got past me.
What are, go ahead.
I'm sorry.
No, go ahead. Go ahead.
How did you, in your opinion, how did you mitigate for the trees you cut down? You said you didn't meet the requirements of your after the fact permit. How do you feel you mitigated?
Well, if you take the total caliber of the plants that they're requiring, it's much less than, you know, the total of what I've put down at this point. I put, like I said, 25 palms down, 45 hedges down, plus several dozen plants, plus I've sodded the entire yard. So I don't know specifically what those trees do to the environment or what we do to replace what's within the environment, but I'm sure that I've gone above and beyond what was required.
See, I just can't help but,
And furthermore, when I originally put this permit in, it took me 7 weeks to get this permit back. She couldn't tell me what my...
which permit are you talking about? You tried to get a permit for these trees in question?
Well, I had to, yeah. I had to, and then it took several weeks for me to get the permit. This one right here,
after receiving the violation.
Right.
You went to get the permit after receiving the violation.
That's correct.
Mm-hmm. Well,
On
The citation and the stop order for the removal of the trees is dated 9/26, and the permit from the planning department is dated
October 2nd.
10/2.
mm-hmm. Mm-hmm.
Okay, well, then I didn't get called for a few weeks after that.
Okay.
Nonetheless, it's not the amount of time that came after the permit. It's the fact that I made a mistake. I missed the palm tree permit that had to be pulled.
Officer Sanderson, what is the total cost on this violation at this time?
Enforcement costs are $34.23.
And what about the civil penalty of 50?
The civil penalty has been paid.
Okay.
That's the initial civil penalty was paid, but there's a notice of assessment running.
Do you have an idea of how much caliper you've replanted? That's the requirement on the permit.
That's right.
Yeah, if you gave me a couple of minutes, I could give you a great idea, and I'm sure it would exceed three palms. They're requiring
15 inches total, minimum size 2 inches diameter at breast height. So it's right on your permit.
You know, I've got to say, Mr. Martise, this is a violation. It's happened before at the same location. You came in before. You were, in my opinion, given a break, and you're here again with a new violation. And I don't like that at all. I mean, it doesn't say much for, I guess, your homework on what you need to do to remain within compliance with code. So the fact that we're here again, Officer Sanderson, what is the recurring penalty? What is that added up to? Do we know?
23 something.
That's probably an incorrect amount, right?
2,800.
Well, as of February 12th, it was $2,834.23.
Cost.
Including cost, okay.
So it was from there till today at $50 a day, plus the cost of enforcement in the original.
Okay. Well, I'd like to make a motion that we find Outlier Investments guilty of a code enforcement violation and fine him with the recurring cost of $2,834.28 or 23 cents.
That's what it was as of February 14th.
Oh,
It's
Sir,
still continuing until you...
Can I say
not yet. I'm
one
not
thing?
finished. I'm not finished.
It's another month.
It's another month on that. So then, does anybody have the final figure?
Well, it'll keep running.
Well, when I contested it, wouldn't that be, I also was saying that it's been corrected. I mean, those have been there for many of those have been there for several weeks. And I'm sure she can contest to that.
So, Mr. Commit, how would that work then? If he is in compliance prior to today's date, and we haven't found that he is in compliance as of this meeting, if he's guilty of code enforcement violation, then how do we apply the correct charges?
You would need to determine what day that the penalties stop or stopped. So,
Which we don't know.
right, unless someone calls for a reinspection, the officers don't go by there every day to see if they've corrected the violation.
And you say the violation's corrected,
Yes.
Mr. Martiz?
And guys, with all due respect, I have several permits in with the city. Yes, I realized there was an infraction there before, but you haven't seen anything since. I have several permits in. I'm opening businesses in the city. I mean, I'm thoroughly trying to do all my due diligence, and this happened because a couple of palm trees were pulled down and it got past me.
Yeah.
I mean, that's a very steep fine for what I've done, and I've more than made up for it. I mean,
Officer
it's
Sanderson.
like you have a personal vendetta against me.
No, that's not the case at all
Well, it
whatsoever. I promise you that.
seems to be.
No, it's not the case at all.
Okay.
I'd like a suggestion from you, since we don't know if or when he put the new palm trees in that he says are in the ground.
Can I make a suggestion?
Yes, sir.
Apparently there needs to be some verification of whether or not he's in compliance. Perhaps this is a case where this should be continued to the next meeting next month, and let planning decide or come back and be able to let the board know if, in fact, he has complied with what needs to be done for mitigation. And if so, try to come up with a date when that was.
Okay. Thank you, Mr.
That's what I would suggest.
Okay.
No, we found that.
Unless Mr. McGarry knows off the top of his head.
Mr. Devine has a question.
Yes, when you were cited and you realized you would have to correct this problem, and you say you corrected it, why didn't you call code enforcement to come out and clarify the fact that you have come into compliance?
Actually, we spoke. I called her immediately. I came here, paid the civil fine weeks ago, and then I told her it would just be a couple of more weeks until everything was done. So
Okay,
I was unaware that the fine was reoccurring at that time. I thought I had paid the additional fine that day, spoken to her, said it would be a couple of more weeks, and then I got this. And I thought by that time I had been in compliance.
Officer Sanderson, do you recall having a conversation with him about the rectification of this code violation?
We did have a conversation, yes. He paid the civil penalty, and he said that things were progressing. He was getting the house ready. It was going on the market, and, he was moving forward. Yes.
Anything mentioned about the trees in that conversation by chance?
Well, that's what the conversation was about.
Sounds like it was about the house being sold to me. But,
Well, it's
Well, no,
total.
I was telling her the timeline that indeed I wasn't making it up. In fact, I had a timeline of having the trees in there and having the house up for sale. So I'm just telling her that I have a timeline.
Okay.
And I'm trying to
I need
stick to it.
from my clarification is because in conversation with my director, Mr. McGarry, he is not in compliance with the conditions of the tree permit.
right.
Okay.
I agree with that.
Okay.
However, the issue I'm having at this juncture is how do we determine what the outcome of this hearing is if we don't know?
Can I interject?
Yes, please. Give me an idea of what. Can I make a motion? Please, go right ahead.
You did have a motion started, but I guess it died for lack of a second.
Right, there wasn't a second.
There wasn't a second.
Thank you.
I'll move that there is indeed a violation, and that we give Mr. Martise and the planning department an additional 30 days to figure out what's going on, and that in the meantime, the penalty continue running, and we can set the final amount when we figure out what's going on. So,
Well said.
So your definition of him coming into compliance is that he meets the requirements of the permit. You are not accepting the money and the
I will
expense.
accept what Mr. McGarry recommends. Personally, I can't speak for the rest of the board.
No, you're good. Just you're reminded that you're under oath.
Look, under this permit, he is supposed to call the person that issued that permit. There should have been an inspection to know if he came into compliance. We have no indications he's in compliance. He didn't do that. Now, whatever that date is, so it's the way it is. I mean, you can come into compliance by paying us just paying a mitigation fee if you want to. I mean, you don't have to put trees out there. So I think we're getting confused here. The problem is nobody was notified that he was for compliance, and we have no record here that shows that he met that.
Right. We still don't know that he is in compliance.
Well, yeah, we have none, and the code requires he should have called if he's in compliance. So I leave it to you. I'm just saying that all indications he's not in compliance at this point.
I have a few questions. Did you, Mr. Howell, say that there were two non-compliances by this gentleman?
He's been before the board before for a different infraction.
Different infraction. So you are somewhat familiar with the rules and regulations of this city?
Well, I don't think it's fair to bring that up with this. This has nothing to do with that.
I agree.
Well, did you ever read the rules and regulations and ordinances of the city?
I've done much due diligence.
Thank you. I would also like to make a statement. I think 30 days is a bit much. I would like to see that cut to 2 weeks before we can figure out what to be done and put a little motion in this process.
I think the issue there would be that we only meet once a month. I mean, I'd like to see.
Well, my thought was that perhaps our inspector could get out there within 2 weeks and update what's happening.
Well, I think it's on Mr. Martise to call for inspection. So it's not up to the city to. The next move is his and not the city.
That's right.
Okay.
That's right.
Was there a second for that first motion?
No. I'd like to second that first motion by Mr. Noonan.
And that was 30 days, and the notice of assessment does continue accruing civil penalties.
Correct. All in favor?
Aye.
All opposed? Motion carries. Thank you, Mr. Martise. Where was that other one? That was Jessica Morris.
This one? Yep.
Okay.
Really?
But that
13
gentleman
CE
and that lady
4513. All together now.
So you're all hand at this.
Jessica Morris.
Yes, I am.
Okay, case number 13-CE-4513, Jessica Morris. Is Jessica here? Hello, Ms. Morris.
Hello.
Have you been sworn in?
Good.
Have you been sworn in?
Yes.
Okay, great. Who did this one? Officer Ramsey.
And just to set the background, this is a request for a notice of assessment. There was no request, I understand, for a hearing, so that was waived, and it's an admission of the violation.
Okay. Officer Ramsey, go ahead.
This is a request for a notice of assessment for case number 13-CE4513. The violator, Jessica Morris, was cited for a violation of shed placement with an expired permit at 1846 22nd Avenue as provided in the backup materials. Service of the citation was provided by certified mail and is provided on file with the city clerk's office. There's been no request for a hearing on the citation, so a hearing to contest the citation has been waived and the violation is deemed admitted by the violator. The violation has not been corrected as of March 12th, 2014, and the civil penalty assessed on the citation has not been paid. Enforcement costs of $41.13 are requested by the city. An affidavit of those itemized costs has been filed with the board clerk, and we request the backup materials be made part of the record. We request the board issue a notice of assessment of continuing penalties, along with an initial civil penalty of $50 and the cost of enforcement of $41.13.
Thank you, sir. Ms. Morris,
Yeah.
you have anything to say?
I originally applied for the permit back in the beginning of last year, and it was never explained to me that we needed to call to have it finalized after the shed was moved. That's why the permit expired.
So you got a permit,
Correct.
moved the shed,
Correct.
didn't have it inspected,
Correct.
Correct.
okay?
And then the permit expired.
Permit expired,
Still.
shed was moved, okay?
So at this point, she would need to go back to the building department, ask them to reactivate the permit and have it inspected.
But it was already moved, right?
Yeah, it's a tie-down issue.
Has it been remedied?
Yes.
It has been tied down?
Yes.
I don't know.
Question for Mr. Clement. Because we have an admission of guilt because they did not file for a hearing, does that mean that we're obligated to fine them for civil penalties
No.
or anything?
No, you can waive the penalty. Enforcement costs would have to be assessed if the city has requested them and filed the affidavit. The city is entitled to recoup those costs.
Can I ask a question?
Sure.
Are you willing to go to the county and get your permit reinstated and have them come look at your tie downs and take care of all of
If
this?
I can afford it, yeah. I mean, I'm the only one working in the household right now, and stuff is tight as it is, and we ended up paying a double fee when we applied for the original permit because it was an after the fact. The shed was put up close to 20 years ago by my mother. So it wasn't until we had some people move in next door that they made it their life goal to harass us any way they can, code enforcement and such. So that's where all this started. But
How much is a permit?
Oh, I just got a shed too.
Two.
They're not real cheap for what
What they are,
it is.
yeah.
they're not cheap at all.
I'm not sure an exact amount. I'm thinking two.
Yeah, I think so.
Yeah. But really, there's no other way to go about doing this in my mind. Because what, Mr. Clement, did I hear you say that no matter what we make a motion, the enforcement costs are due?
The enforcement costs, unless the city waives them, would have to be assessed.
Okay.
You don't have to impose a civil penalty. And in this case, I mean, if she thinks she some more time would allow them, rather than issuing a notice of assessment, you could continue the case to a later date to allow her some time before you take that next step of a notice of assessment.
Because see, if you don't get the permit reinstated and have it inspected, you're going to end up right back here again.
Right, right.
You know,
Yeah, I understand.
City Officer Ramsey.
I'm okay with extending the time frame. I understand that she didn't understand what the requirements were. We do want cost and the citation payment. Other than that, I'm okay with staying the civil penalty for 30 days until we get a chance to have it reinspected and reissued.
Okay.
30 days enough to
I'll make it work.
pay this penalty
I'll
and the
make it
permit
work.
fee?
Yep.
Okay. I'll make a motion that we give Mrs. Morris 30 days to come into compliance, to go to the building department to reissue that permit and to have it inspected and approved. And we'll wait until that 30 days is up to revisit the enforcement cost and the civil penalty as well.
I second the motion.
All in favor?
Aye.
Aye.
All opposed? Motion carries. Thank you, Mrs. Morris.
Thank you.
Case number 13-CE-4487, Jose Barajas.
We have parties here for another case for a board
Oh, we
order.
do?
Do you want to hear that first?
Yeah, I'd rather do that. Who are they for? Officer Ramsey?
13 CE-4404, Courtney Jones.
Okay, Courtney Jones is here. Yes, let's do that first. Case number 13-CE-4404, Courtney H. Jones. Hi there.
My name's George Jones. I'm Courtney's father. And I know this is like shutting the gate after the horse has left the barn, but this was a yard sale that overflowed the front yard. And my sister-in-law's house was foreclosed. Some of her stuff got there. It didn't sell. It sat there while she got somebody to come pick it up. Habitat for Humanity or somebody. I don't remember who it was. He didn't come before because he didn't understand that he thought all he had to do is clean it up.
And we don't have internet, so I couldn't get on and read any of that.
My wife and I have a very small mom and pop flower shop, Monty's Flower Market. And this occurred during one of our more busy times. My son and his wife do not work, haven't had jobs in some time, and so they help us. And they were helping us making deliveries and processing flowers and stuff during all of this time, which took them away from some of this, I guess, more important things. To compound the felony, my wife had emergency gallbladder surgery on the 29th of December and was in the hospital until the beginning of the following week, which runs up to whatever this enforcement date was.
Can I interrupt you just one moment, Mr. Jones, right here?
I'm sorry?
Just one moment. I just want to clarify, were both of you sworn in?
Yes,
today?
Yes, we were both here and
Okay.
raised our hands.
Okay,
I
thank
do.
you. You may continue. I apologize.
Oh,
Go ahead.
no, that's fine. They're in compliance. He has 3 children under 7. They are living in the house with us.
What little bit I
It
get
is.
helping make deliveries and stuff with them goes to feed the kids and take care of their needs.
It is an economic impossibility for him to pay these fines. And I was extremely happy to hear that your function is not for punishment. And since it's been corrected and you've gotten his attention, it will not happen again. I am here asking that you waive the fines and the enforcement cost. And interestingly, the enforcement cost for this is more than any of the other cases that have come before that seem much more involved. You know, one was 34, one was 40 something. This is $50.54. So I'm just asking for your good offices to try to help us out of this situation.
Officer Ramsey.
I'm not really sure where to go on this. I know they have had circumstances, medical circumstances. Courtney's wife had emergency surgery that got him out of last month's hearing. And I would ask that we get at least the citation and the enforcement costs and leave it to your discretion as far as the notice of assessment fee penalties that have been assessed to this point.
Mr. Ramsey, have you inspected the property?
Yeah, it's in compliance. It has been since February.
Thank you.
Mm-hmm.
I believe we had it completed before that date as well.
You may have. Again, absence of phone call from you telling me to inspect.
I do apologize for that. With everything going on, it just got lost in my shuffle, and I'm sorry that happened.
Understand.
Pardon me. Officer Ramsey, what are the costs of enforcement? What is the cost? Is it $50.54?
Yes.
Correct.
The civil penalty is $50.
Correct.
And then a continuing penalty is what the problem it really is.
I understand that. you're in compliance now. Does anyone have any questions for Mr. Jones? Okay, I'd like to make a motion that this is where Mr. Comment's going to get me, that we find the property is in compliance, but that we also find the Mr. Courtney Jones for the cost of enforcement of $50.54, and also for the civil penalty of $50. What part did I miss, if anything? Is it?
You were close.
Well, that would be the total then that you're assessing. That'll override the notice of assessment that was issued.
So
if you're setting the total civil penalty at $50 and assessing the enforcement cost requested at $50.54, that would be what the final order would be.
Can I make a motion to issue a final order at this?
That's what we're doing.
Yes,
Okay.
since you're in a
And
compliance.
you're under final order right now.
Okay. Well, then I'll make a motion that the board issue a final order, and that we also incur a cost to Mr. Jones, Mr. Courtney Jones, of enforcement cost of $50.54 and a civil penalty of $50.
Did you consider dropping the civil penalty to the hardship, or?
I would consider it.
I would second that if
Okay.
we just collect the cost of prosecution.
I strike the
City's
civil
money back.
penalty, and the enforcement costs remain $50.54. Do I have a second?
Second.
All in favor?
Aye.
All opposed? Motion carries.
Thank you very much.
Thank you, Mr. Jones.
Can I have until the 4th of next month when my Social Security comes in to pay the fine?
You'll have 30 days from the
30
date that the
days,
order
okay.
is issued.
Yes.
When that comes, I can pay the fine for him.
Great.
Thank you very much.
Thank you
sir.
very much.
Mr. Chairman, I think you have somebody else, a couple of other people present.
Anyone else?
Afraid to look.
Is anyone else here to speak about a case? Yes.
Start with her first.
Yes, ma'am. What is your name? Carrie Ann Jones.
My husband is out of town, though. I'm here on behalf of J.B. Jones Jr.
Oh,
I see. Okay, and were you sworn in?
Yes, sir.
You were. Okay, come up to the podium, please. This is case number 13-CE-4457, J.B. Jones Jr.
Ma'am, were you here before? I just saw you come in a few minutes ago.
I ran to use the restroom.
Oh, okay.
Sorry.
I just saw her walk in.
Can we swear somebody
Oh,
in
I've
twice
been
as a
here the whole
precautionary measure?
You said that you were sworn in, correct?
Oh, yes, ma'am. I've been here since
You have, okay.
before it started.
Oh, you did see her? Okay, okay. I apologize.
If you're not going to believe her when she says that, then it's not going to do any good to swear in again.
We just like it on the record.
You're right. Officer Ramsey, would you give us the background on this one, please?
Yes. This is a request for a board order for case number 13-CE4457. The violator, J.B. Jones Jr., was cited for a violation of excessive exterior storage of trash, debris, and other materials at 1415-1417 38th Avenue, duplex, as provided in the backup materials. Service of the citation was provided by certified mail and is provided on file with the city clerk's office. As of this morning, the violation has not been corrected, and the civil penalty assessed on the citation has not been paid. Enforcement costs of $45.99 are requested by the city. An affidavit of those itemized costs has been filed with the board clerk, and we request the backup materials be made part of the record. We request the board issue a board order, along with an initial civil penalty of $50 and the cost of enforcement of $45.99.
And there was previously issued a notice of assessment of continuing penalties, which commenced running on January 11th of this year. at $50 a day.
Correct. And they're ongoing, as it's not up to date.
Thank you, sir. You said your name was Mrs. Jones, correct?
Yes.
Go ahead, Mrs. Jones.
I
Will
believe
you just
it's
state your
for-
first name?
Spell my name?
Just state your first name for the
Carrie
record.
Ann.
Thank you.
I believe it was the first week of January. There are tenants in both the units. This has to do with the one in the back, 515, I believe, or 1415, excuse me. From the tenant with the police officer on another, standing next door. There was a domestic call from Dawn. She had, from what I gathered from the officer, had somebody that she had met move in to the property. I guess that this woman had paid her some rent, and when they got in an argument, she ended up putting her in a shed. Literally moved a person, and that's where she stayed. The officer said there was blankets. So it was actually she was living in the shed. That was about 10:30, 11 o'clock at night. So we had her go in the house. Officer said she can't stay outside since she paid rent. You need to put her up in a hotel or make her go, she has to stay in the house. So I told my tenant, you need to bring her in your home because I'm not going to, I can't afford it, first of all, to go put somebody up I don't even know. My husband drove up there that evening, and we lived in Port St. Lucie. Our house was foreclosed on the 2nd of January. And so when we drove up there, we dismantled the shed. I don't know if code enforcement was there that night, but there was a lot of other people there that night because of the situation. And the code enforcement said this shed needs to be taken down. So that night, my husband went up there, and him and the tenant's boyfriend had taken down the shed. After that, next day or two, the tenant Dawn had sent me pictures of everything cleaned up, which I've seen his, with everything cleaned up. And at that time, I had not gotten any paperwork for anything. It was just the phone call from the police officer coming out. And I believe it was around at the end of February or March, it was February 28th, where I received my forwarding mail from my previous address, where it had this packet, but this is the new one, but it had the same one, but with a February 12th, and I'd received my mail on the February 28th. I immediately that day drove up here to see Mr. Ramsey, sorry. He was not in, so I'd spoken to who was ever at the desk. I left him my name and phone number, and I actually had the envelope where it had the forwarding mail, and when I actually received the mail with the information. So I called Dawn back, and I let her know what was going on, and by that time, the fines were $1,700. And there was in the beginning, there was a $50 fine. And I got that all at the same time. I saw him, and he had said, well, there are still things out there, because I had thought it was the shed. And there was a dog run, a refrigerator that they had needed a new one and put the other one outside, and I believe a bird cage is what Mr. Ramsey had spoken to me about. So I called her. I said, put the dog run. I asked him if the dog run is not a fixed structure, because they said when code enforcement was there that it was in the backyard at the time. And Mr. Ramsey said, well, now it's in the front, and he said you can keep it, but it needs to be moved back. So I spoke with Dawn, and I asked her, the bird cage needs to go in the house. The garbage and the things that are on the side need to be picked up, and the dog run needs to go in the back. And the refrigerator had already been taken away. And she sent me another text. I called Mr. Ramsey. He said, I'll go check it out. And called me and said, it's still not in compliance. And, now we have a hearing. So my whole thing is I don't mind from the date that I was aware of the original $50 fine and everything. I believe from the 28th of February, I don't mind being fined from when I first knew until I get into compliance. I can deal with that. Because I would never not show up for a hearing or not comply with the city. It just doesn't make sense.
Thank you. Officer Ramsey.
Again, I think it's a situation where her tenant tells her one thing, tells me another, does one thing, and just three different things. There's been a lot of confusion, but I was out there again this morning and I spoke with the tenant. It's still not in compliance as of this morning. Again,
Haven't we fined tenants in the past?
Well, that's what I was going to ask. Do we know who the tenant is? Why have we cited the tenant?
well, no, we have not cited the tenant. We cited the property owner.
I mean,
The tenant, as she indicated, was kind of a fluid thing. There was.
has this always been the same tenant throughout this process?
She has been here, been in the property, I believe, over 3 years.
Yeah, but she's brought other people. She has a new person in as of today.
Yeah, the problem is when you have a tenant, they're in possession of the property, and they kind of control the property.
And being in all the way in Port St. Lucie now, it is difficult. I mean, when she sent me a text, I don't know, it's our building. It might possibly be the other side, though. You know, but I'm telling her that I can't keep accumulating this fine. You need to work with it. Oh, I've got it. It's everything's 100%. So my thing is today, if I have time, just to go home, pick up the truck, and go do it myself.
Ma'am, Tom, do you have the tenant's name?
I have first name.
Can you give him their full name?
Absolutely.
And you got the address.
Yeah.
I mean, you could cite the tenant.
In the past, we've cited tenants.
I would much
Yeah,
rather do it.
typically
They
the
would
tenant
comply.
and the owner can get cited too.
I would help them comply because it is my building. It is my responsibility of who I have in there. But I
Right.
do believe that, the tenant, she has no reason to comply. She has no incentive.
Which is the reason we cite the homeowner.
Yeah.
Do you have a written lease with this person?
Yes, sir, I do.
Does your lease provide that if they violate the law, you're going to kick them out? You're going to evict them?
Honestly, I don't know if that.
I mean, you should have that in your leases. And, I mean, I'm not your attorney, but I would have that in my leases. And if they violate the law, you start the eviction process.
Mm-hmm.
Since this has taken us this long, I can always find another tenant, which is not a problem. But for her to be doing this and telling me one thing or sending me a picture of something, I mean, I know she's not running around and hiding it somewhere and taking the picture, so she's flat out lying. And knowing this is a carrying, ongoing penalty, I'm just I would evict her for this anyway. Besides of what she did, no human being would rent a shed. She rented a shed. The lady was urinating in a can.
Oh, God.
Mr. Devine, did you have a question?
I have a question.
Yes,
You're
sir.
the property owner of this domicile, and as a owner, don't you go and do on-site inspections every now and then to make sure your property's being kept up in a reasonable manner?
Yes, we have. I think it was up until she has been okay. It all started. We would rarely even really speak to her. You know, everything was run right. She pays her rent. The property's been because there's a tenant in the front too who's very different, opposite of her. So they would sometimes call and say, there's something, and we would come out there. But before she started moving, I don't know if it's. I mean, it's. Both of them were intoxicated at the time, both women, and they were mad at somebody took somebody's alcohol, so she put her in a shed. So I don't know if it's something new but it's ever since that she had tried to put somebody in the home with her, we only rented it to her. So, but the officers were saying, well, you have to evict. I said, if I have to evict somebody who's not even on the lease, then I don't know who. You're going to. And we actually paid for the lady. We had to help her find somewhere to move, and I think we actually gave her $300 to move this lady out of our unit to have no more problems with her because she was calling every night because they were fighting. But I said, you can't kick her out because the police said you can't throw her out on the street or we'd have to put her in a hotel. So we said, you brought her there.
Advice.
She paid you. You need to let her stay until she can find a space. So
Okay.
Well, I don't think her paying all these fines is going to do anything to solve the problem.
Right.
We'll go
Do we
up there
need a
myself.
motion
But-
to find or to cite the tenant?
No, you don't need that. I mean, that's up to enforcement whether or not they cite somebody. But maybe this is another one where you may want to just put this off till next meeting and let the lady take it upon themselves and go clean it up. And then if
Hash
it
it out
gets messed up again, the tenant gets
actually,
cited.
we'll be doing an eviction at the same time.
I have a
So
question.
honestly, if we did serve the tenant and she gets evicted,
Should be gone.
She'd be out of here.
we've lost any leverage we have at that point.
Well, maybe she'll be gone.
Question.
Yes, sir.
How long do you
moving to the
think
shed.
it's going to take to remedy the situation?
Sir, I can remedy it and give me a couple of days.
How many days
Okay,
would you say?
Give me
Best guess,
4.
4 days. She's on record for 4 days. Can we give her 4 days?
I'm afraid she might
I'll
run
give her
into
till
some.
next meeting.
I'm afraid she could possibly run into some problems with this
4-day eviction would be
person. I
pretty
mean,
Could you take a few more days just to make sure?
these things sometimes can, from what I understand, can drag out as long as 3 months before you can get somebody legally out of the.
No, I'm talking about cleaning up the garbage.
area.
Oh, sure.
I'm not
Yeah,
talking
so
Well,
about the
I
tenant.
can obviously work with her and tell her, if you don't help me clean this up, I will throw it away. If you don't bring it in your home or throw it away or find a storage,
See,
it cannot be outside of this property.
The problem she has, and I'm just talking as an attorney here, having to do with real property law. She has a tenant, so the tenant is in possession. She can't just arbitrarily go in and start throwing away her tenant's possessions.
That's true.
She
Right.
can't do that.
You're going to be
I
limited.
So-
sir, I'm sorry. I wouldn't do that, but I would tell her, either you can help me and remove your own things. I will help you. If you need help, I will help you. Or we'll have to do an eviction, and it'll be done that way. It'll be getting rid of that way.
That's
But
why
We should do
I'm
both.
thinking, again, it's
Mr.
the
Ramsey.
call of
Don't put too many details on the
Let-
record.
let Mr. come in,
Sorry.
finish.
just, again, it's the call of the enforcement folks on whether or not to go cite the tenant, but that might be the impetus that she needs to get it cleaned up. I mean,
In speaking with the tenant this morning, she said she would have it done today. Now, she's told me this
She's
before,
told us both this.
but she has cleaned a lot of it.
And not only that,
It's 2 pickup loads.
I have a concern as well that and I don't know how this works, Mr. Commit, but if we redirect the fines to the tenant,
We can't do that.
well, not this case. They would have to be cited initially.
I see. So, okay. I think I know what I'd like to do then, because the city has still incurred quite a bit of cost from going out there and coming back and going out and coming back and being here and having a case. So, I'd like to make a motion. I'd like to make a motion that we issue a board order for the civil penalty and the cost of enforcement, but not the recurring cost of
Well,
notice.
see, you're closing the case then,
Okay, I don't want to do that.
and it's not complied. You would typically want to find a compliance.
So we basically would
First.
have to continue this then. If we
That's
didn't-
again, that's what I would recommend.
If we didn't want to say that.
I would recommend that,
Right.
since you don't
Right.
have the tenant in front of you and it's still not complied.
Okay. Okay.
May
I'll- Yes, sir.
May I ask Mr. Ramsey another question?
Yes, sir.
According to this complaint, the garbage, rubbish, trash, debris, dead trees, and other, has any of that been cleaned up?
Excuse me. Yes, a lot of it has been cleaned up.
So what is still there then?
I can show you pictures as of this morning.
Please, I'd like to see some pictures.
Me too, please. Okay. Okay, thank you. That way when we'll go over there when I leave here to go speak to her.
No. Yeah, of course you can.
That's the
Is
back
that a-
of the residence.
No,
Is that an AC unit?
no, that's a dog
It's like a kennel.
crate.
Oh, that's a
Yeah.
kennel.
This is probably 10% of what was there.
Wow. There's the dog.
Okay, that's a dog kennel. It's, yeah.
What are we looking at? The back to the side?
That's the front of the front door right there.
Oh, front door.
In
Front
her
door.
in her home.
Those,
So she's renting
those
out.
pails
She's
side there.
subletting. Oh,
they
so
are
sorry,
empty,
I was-
catching rain.
Okay.
Isn't that a health violation of some sort?
Yeah, it would be, yes. I mean, they're not right now. There was no standing water in it or anything, but
What I'm saying is those are open buckets catching rain and could be a health hazard.
Oh, okay.
you know, part of the problem is no sooner than she removes some items, new items appear.
He's a magician. Could you go back to the first picture, please?
What's under the tarp?
Yeah, right.
Oh, that's the
It's
dog.
the back of the dog kennel.
Uh-huh.
It's the dog
on
kennel.
the other side, I see. This is the back side.
The back of the
Oh, okay.
Okay.
Oh, okay.
So the dog kennel will, I'm sorry. So when the dog kennel, because it will take 30 days longer to do an eviction, because this looks like it will be occurring over and
Like
over
we
and
got
over.
American flag.
And I really just don't want that. But as I was asking, the kennel, the big kennel, that can stay in its spot, but everything else looks like it's either garbage or can be removed. It doesn't need to be there. It's not. So if the kennel would be okay?
Correct.
Tell them the kennel and maybe the table, the backyard table?
That's fine as well.
Okay.
Is that a stove to the extreme lower right? What is that?
Chimia. What is it called?
The little fire burning
Oh.
Oh, I'm not familiar with it.
Me neither.
little wood burner.
Okay.
Okay.
So then, in this case, I'd like to make a motion that we extend this case for 30 days and bring it back to the Code Enforcement Board next month.
I'll second that.
All in favor?
Aye.
All opposed? Motion carries.
That would be actually April 9th when it would come back to the board.
April 9th? Okay,
Next meeting.
next meeting. Well, I amend the motion to reflect the next meeting then. All in favor?
Aye.
Motion carries. Thank you.
Thank you. Thank you.
I hate to extend the meeting longer than necessary, but I'd like to call a 5-minute recess, please. Thank you.